Well, folks, good morning. My name is Sam S. Stryker. I teach labor and employment law here. I direct the Center for Labor and Employment Law. And one of the features of our center is our members are actively involved in contributing their time and money to our programs. And this is an occasional morning seminar. We do one each semester in addition to our annual conference on labor in June and our 21st annual program on employment law for federal judges, which will come out in, was it March? March. In March. So we have a pretty heavy calendar. This is Allison Schaffini. She is one of the managers, administrators of our center, and she is the power behind this center and its effectiveness. Our topic this morning, of course, is Me Too, assessing its impact. Last year, we had a conference on the same topic. We called it we had a different title. It was called Avoiding the Next Harvey Weinstein. And it seems we have not effectively avoided the next Harvey Weinstein, unfortunately. I think the program is not only about sexual abuse and sexual harassment, but other aspects of fairness to women in the U.S. workforce. We are proud to have two co-sponsors that have been very helpful in generating an audience for the program. One organization is NYU Law Women, which is a student organization, and the second is the Birnbaum Fellowship for female leaders in the law, and we thank both of those organizations. I'm going to play a backseat role here. Our moderator is Davida Perry, who is one of the founding partners of the firm of Schwartz, Perry, and Heller. She has established a reputation as one of the most effective lawyers on the employee side with a specialty in sexual harassment, sexual discrimination issues. She's brought some landmark cases in the field, including a lawsuit against Penthouse Magazine, which I don't believe I've ever opened the pages of. Prove me wrong. And the case of Bracker versus Cohen, one of the first sexual discrimination lawsuits under New York City human rights law. She's very highly rated by people on both sides of the fence, or I should say all three sides of the fence, because there's also a public side. I'm going to turn it over to Ms. Perry. Thank you.
Thank you, Professor S. Stryker. I'm thrilled to be here today to moderate this panel about a subject that in the past year has become nothing short of an international phenomenon. So it's going to be very interesting to talk about how far we've come this past year. Our esteemed panel of presenters all have very impressive bios. I urge you to read the materials you have before you. In the interest of time, I'm only going to summarize them. Sitting to my right is Charlotte Burrows. She is the commissioner of the EEOC, having been appointed by President Obama. Before joining the EEOC, Commissioner Burrows served as Associate Deputy Attorney General at the Department of Justice, working on a broad range of civil and criminal matters, including employment discrimination, combating racial profiling, and implementation of the Violence Against Women Act. A veteran of Capitol Hill, Commissioner Burrows previously served as General Counsel for Civil and Constitutional Rights to Senator Edward M. Kennedy. Before working on Capitol Hill, Commissioner Burrows litigated employment cases in the Civil Rights Division's Employment Litigation Section at the Department of Justice and rose through the ranks there to become Deputy Chief. To my left is Gary Friedman, a partner and first chair trial lawyer in Weil Gotshall's litigation practice, representing management in all facets of the employment law field. Gary has particular expertise litigating nationwide on behalf of employers in discrimination and wage and hour class and collective actions, defending companies in suits involving C-suite and other senior executives, and prosecuting or defending restrictive covenant and trade secret matters. Seated next to Gary is Erica Ozer. She is currently the Global Head of Human Resources for one of Swiss Re's 3 business units, Life Capital. Erica is responsible for defining and implementing the business unit's people strategy. She also consults counsels and coaches in matters related to their employee and facilities key processes globally, such as compensation planning, performance management, talent development, and succession planning. And seated next to Erica is Christopher Riley. He is presently Associate General Counsel for the Pitney Bowes HR Legal Group and is based in Connecticut. He partners with the Pitney Bowes Global Human Resources, Legal and Management teams to provide advice and solutions on employment-related issues, including compliance, claims, and investigations. And seated next to Commissioner Burrows is Kara Green. She is a partner at Outten & Golden, where she represents employees and partners in all areas of employment and partnership law. She is the current chair of the New York State Bar Association's Labor and Employment section and is a frequent speaker on sexual harassment and other employment-related topics. In terms of format, we're going to leave some time at the end for a panel discussion, and then your questions, which please save because we really want to hear from you. And without further ado, I'm going to turn it over to Commissioner Burrows.
Thank you. Good morning. It's so great to be here with all of you. I'm really happy to be inside. I think I'm probably the only Southerner in the room, and it was really cold out there. So I'm not looking down to write emails. I'm making sure that I'm disciplined because I am a Southerner and I come from a long line of Baptist ministers. So that means, for anyone who doesn't know, I can go on a bit. So I'm going to be disciplined. I'm going to have my clock here. If I'm looking down, it's only because I'm keeping myself honest. I'd like to first thank Professor Estreicher for having us here, and also, of course, NYU Law, the NYU Law Women, and Birnbaum Fellowship. And it is a pleasure to have the chance to engage with all of you on what I think is a really important conversation. In fact, I was saying earlier, it's almost like we're having a national conversation in little increments like the one today. And I think it's really important because what I believe, and I am certain this is true, but it only will be true if we do our work, all of us in this room, is that we're at a moment where we can actually fix a problem that has been an ongoing issue for America for a very long time. And this question of sexual harassment and harassment in general, and who has power in the workplace, and how it's used, and who's considered worth what, that's the issue. And we finally have the first part of fixing that problem in front of us and already done, which is everyone now knows it's an issue. So the first thing I want to say, I'm going to talk about three things. What's changed, since that is, in fact, how we build this program. What's changed in the last approximately 1 year since the Harvey Weinstein announcement was on the front page of or allegations were on the front page of the New York Times, and 1 year since the Me Too movement, which has been a movement for well over a decade, but it went viral about a year ago. To state the obvious, so that's the first thing, what's changed? Second thing is going to be what didn't change, right? And then what's next? So to state the obvious, what changed is we're all here talking about it, and the Me Too movement did go viral, and it gained worldwide attention so that we have employers and employees understanding what we at the Equal Employment Opportunity Commission have known for a very long time, that this issue should be front and center for all of us. And just over a year ago, this national conversation began, which was so very overdue. And of course, as all of you know, there's been an incredible level of media scrutiny on celebrities and other individuals in high-level positions of power who've been accused of harassment in the entertainment and restaurant industries, and you can pretty much name any industry. And it may be too early to know for certain whether I'm right, whether or not we're really going to have the cultural will to change what is a very significant cultural problem. It's not a legal problem. We have the laws on the books. I think this is an audience that's well aware of that. And nothing changed about the law, particularly a year ago. But what has changed, and there are two big things that I think are important in terms of the big changes, and I have been lucky enough to kind of see them in real time because of the work that the commission does. The first is that people are willing to speak up, at least with respect to sexual harassment. The second thing is that more employers understand the need to get in front of the problem. It's changed the idea of, well, is it worse to know and we'll create this record if we investigate and then there'll be proof that there was a problem, right? That was some of the thinking. No, it's changed the default so that it's much better to know and deal with it early. That was always true, but employers now understand it. And the difference that makes me the most optimistic is that survivors of sexual assault and other harassment are increasingly speaking out about their experiences. And I think the reason is that these high-profile dismissals, this drumbeat in the media has actually made people believe that something can change if you speak out. A report actually can change the situation. It's not that people aren't still terrified about their careers, aren't still worried that they'll be blackballed or there'll be a dead end. It's that they have seen that in some cases at least, it changes things. And as a result, 13.6% increase in EEOC charge filings that deal with harassment based on sexualized conduct. So sexual harassment, which sometimes you see it referring to all sex-based harassment. We talk about the come on versus the put down, right? So I'm just talking about the come on. The put down is anti-women harassment. You're not good enough to do the job, other things, maybe. In construction, we see a lot of working with, messing with people's tools, sabotage. I'm just talking about the sexualized conduct, 13.6% increase. We have also, our state and local counterparts, including here in New York, have seen increases as well. New York, I think, is about 50% increase in people reporting. California is around 50% as well. Other states, less than that, but everyone is seeing this change. We've seen a huge increase in the number of hits on our website. We filed more than double the number of sexual harassment cases last year than we did the fiscal year before. And we were able to recover $70 million in both our administrative process and in the formal litigation process. When people don't settle, we take them to court, obviously. And that was also a big increase. The year before was something in the neighborhood of $45 million. And again, I'm just talking about the harassment that's based on sexual conduct. The other major difference, now that the media has created this space through the public attention, and pressure continues to mount, frankly, to do something about it, is that employers are trying to get in front of the problem. And I think very sincerely so. And so we have been working very cooperatively with a number of employers in all different industries, both in sort of formal outreach ways and in separate sort of quiet conversation ways about how to get in front of this. We've increased our outreach efforts in training and technical assistance. We're fortunate to conduct over 1,000 outreach events for employees as well so that they could help know their rights. And we launched in October 2017 a Respectful Workplaces training that talks about how to get a workplace where you don't have to worry that there's severe, even criminal, as some of the things that we've seen in the news, are kinds of harassment going on, because you've stopped it at a level where you've created an expectation that there's respect and civility in the workplace. We can talk more about that later if there's anyone who wants to hear about it. And so although we are taking a very collaborative approach to that, EEOC is actually not a gotcha kind of agency. We like to fix the problem, and we know that we have a lot of tools in the toolbox, and working with people who want to sincerely fix a problem is one of the ways to do that. At the same time, we have had a lot of success in litigation, and as I mentioned before, have been very forward-leaning in using that tool as well. So over the summer, we've been packaging some of these lawsuits just to make it clear to people that we are, in fact, serious, and did that a couple of times over the summer, lawsuits from Los Angeles to Birmingham, because I think it's important to remind employers that while we are collaborative, we also, understand what our duty is and are not going to abdicate in terms of using all the tools that we have to fix it. One of the things that, if you are interested in learning more, I think this is in your packet, but there's a short document we put out on the website about what you should know. EEOC leads the way in preventing workplace harassment. I want to talk about one other thing that has changed, and then I'll talk about what hasn't changed. The last thing I'd like to say is I've started to notice that courts have been changing the way they look at summary judgment and at some of these claims. And I find that fascinating. One case that I wanted to flag, it's a little too early to tell if this is going to be a long-term shift or if it was just sort of in the moment, but some courts have been making decisions that I think would have come out differently a year and a half ago. And in at least one case, it seemed pretty clear that that was what was going on. The case is called Minarski versus Susquehanna County. If anybody who's a law nerd wants to look that up, it's 895 F3rd 303. And it was just a regular sort of district court overturning. So the district court had said, look, there's not enough evidence here that that there was harassment, or rather, there was evidence of harassment, but that the employer had satisfied its duty under Farragut-Ellis to show that it had done everything reasonable, and the victim, the survivor, had failed to report, and that she was unreasonable in doing that. And to cut to the chase, this is one of those cases where you had a very clear repeat harasser. This guy was like known to be grabbing women under the mistletoe at the Christmas party, right? And he did this every year. Everyone kind of knew it. He had a secretary. He was actually the director of the county Department of Veterans Affairs. And this secretary was part-time, and when she came in, she was working with him in an isolated area where nobody else was really around. And so he would grab her and hug her and kiss her, and this goes on for like 3 years. And he knew that she was a single mom with a very ill child who desperately needed her paycheck. So she's also aware that in the workplace there are other women who've had this. She knows about the Christmas party. She actually finds out that at least one of them, there's actually been 2 reports that were kind of a slap on the wrist, no written reprimand, but sort of a oral warning. And she finds out about one of them. So she concludes that she's not going to report until it gets to a point where either her physician tells her, you gotta do something, this is making you unwell. She writes him an email and says, I really feel uncomfortable with what you're doing. She never formally reports other than that email. He says, okay, I'll stop immediately. I resent the fact that you put this in email. It looks like you're trying to set me up. Anyway, it turns out that she tells a friend, and that friend it's overheard, and somehow the employer finds out, and they dismiss him pretty promptly, right? And she never reported except to tell him to stop in that one email. As far as we know, he would have stopped, but then they found out about it and caught him. So he gets fired pretty immediately. The district court said, look, the employer did what they needed to do, and so it's been overturned. And the Third Circuit says, well, wait a minute. And this is the part that I think is really interesting. And so I'm going to take a minute and just read what it says in footnote 12. This is a quote, in the midst of national news regarding a veritable firestorm of allegations of rampant sexual misconduct that has been closeted for years and not reported by the victims, this is how we are considering the case. So it introduces, this is the context that the court sees the case. And acknowledges that harassers often have such control over the harassed that many do not come forward, and that a jury could conclude that not reporting is understandable, or as the court stated, perhaps even reasonable. So that decision also referenced several articles, and I have to say I was happy to see that they referenced a report about that the EEOC had put out from our select task force on harassment, to explain how widespread and underreported sexual harassment is. So I don't know how much this will become effective, but I started to see cases, and I wanted to flag that for you because I think it's changing the balance a little bit in terms of how these things go. I'm not going to spend too much more time on that, except to say that the National Law Review also recently highlighted an article indicating that juries are also starting to think about what's reasonable in terms of reporting more. What we have found at the EEOC is that something like 75% of people who say they were harassed at work never report it to anyone, and certainly not in any formal sense, and certainly not to the federal government. And so that puts in context, again, where I started, this 13.6 increase of folks coming to the EEOC is really quite remarkable in that 1 year. So, in addition, Massachusetts juries apparently are awarding punitive damages at much higher rates. What has not changed is that EEOC has been at this for a long time. I mentioned the bipartisan task force. We started that in 2015. Two of my colleagues, one Republican, one Democrat, led that for about 18 months so that we could figure out, because we knew, just because we get to see all the ugly, and I'll just leave it there, we knew that this was a five-alarm fire in American workplaces. And so we needed to get ahead of it. And we took the time, which government normally does not have the luxury to do, to take 18 months. And we brought in employers, unions, academics, folks from all different walks of life to figure out, okay, how do we prevent it? We all have this same interest, but how do we get in front of it? And so I would commend to you both the task chair's report from, the co-chair's report from that task force, which is on our website, as well as a very short, so it's well written, but it is long. We also have a Cliff Notes version, which talks about promising practices for preventing it, and I firmly believe that if you take that, it's gotta be 5 to 7 pages, and do everything that's on there, you are well on the way to being very safe, or, not that nothing will happen, but you'll be ready for whatever does. I wanna say, in addition, so that's kind of what's not changed. We've been working at this, and everything is ramped up because now we are responding to the fact that everyone's sort of caught up to us. But fortunately, I think we have some building blocks at the commission, and I want to emphasize that while this problem seems and it is big and it is complicated, it is fixable. And the message from our task force is that, and I really do believe we've sort of put together a blueprint that will be helpful. We can talk about that. I'm happy to answer questions. 2 things. Leadership has to come from the top. Top has to have absolute buy-in and communicate what's tolerated and what's not tolerated. And then you got to go to the middle managers, because the message from the top is necessary but not sufficient. You got to go to the middle managers, and they have got to understand that this is as important as every other thing that's relevant to the bottom line for profit and loss. So the last thing I would say is we've got to understand that this is a 5-alarm fire, not just on the basis of sex. We have, unfortunately, on pretty much every basis that our statutes cover, including at least one case on genetic information, that we have a real problem of harassment in American workplaces. And we see cases, particularly in certain industries, but you'd be surprised, where we have discrimination based on race that leads to harassment, that leads to physical violence. That we have, prosecuted or litigated a case where a Jewish man was thrown into a garbage can for the amusement of the supervisors who were watching, and they called it, this was a culmination of years of things, but they called it throw the Jew in the garbage by his coworkers. So there is a problem that we need to take this moment and broaden out and understand that we've got to look at this more seriously as to how people are treated in the workplace and take a comprehensive view. So I'm going to stop there because I think I was a little Southern and went over my time. I'm good? Okay. But I really want to emphasize that. And one thing that we do a lot of farm worker women cases, and some of them are, we find a lot of patterns that are frankly criminal. And one of the things that I was struck by in terms of understanding the breadth of this problem and the common threads that go through different industries was the letter about a year ago when the Weinstein allegations first came out. The farm workers sent a letter. I'm going to look and see if I can actually read just a little bit of it, because I think they sort of pointed the way. Alianza Nacional de Campesinas, this national organization, said to Gwyneth Paltrow and all of these powerful women in Hollywood who were talking about sexual harassment, don't be afraid to speak up because you think you're too privileged, right? That you're not whining. And what they said, to quote precisely, is we work in isolated fields and packing houses that are out of sight and out of mind for most people in this country. Even though we work in very different environments, we share a common experience of being preyed upon by individuals who have the power to hire, fire, blacklist, and otherwise threaten our economic, physical, and emotional security. And so what, as I understand it, the conversation was a little bit, well, we get millions of dollars a year. Should we really, are people really gonna understand the plight of this? And what the farm worker women and a lot of women who work in janitorial services and others have come forward and said is like, look, if even you can't stand up, there's no hope for the rest of us, right? And that we also can see and sympathize and empathize with what you have. Don't be afraid that, we're gonna roll our eyes and say, how dare you complain? Quite the opposite. So I will stop there, and I thank you guys. I'm looking forward to the conversation.
I have a question for you.
Absolutely.
As a result of Me Too, do you think that there's sort of a shift toward believing the victim at the inception of the complaint in a way that was different before these powerful women came forward?
I do think that there's a shift, and that's part of what I thought was interesting about the National Law Review and the discussion of the Massachusetts juries. And again, okay, it's Massachusetts, but it's not my home state of North Carolina. But I do think that people are sort of going, okay, let's take it seriously. And, time will tell about that, but I think that the stories kind of speak for themselves. And I do think that there's, in this whole sort of, well, it's a he said, she said kind of conversation that often comes up. There's also something about witness credibility, right? If you're on a jury and you hear someone talk about this, you can imagine, and everyone will be able to assess the credibility. So I do think that there's a more of an openness, but I don't. That's anecdotal, solely.
Okay. I mean, I know a lot of women say that they're afraid, or victims, it could be a man too, are afraid to come forward because they're not going to be believed. I'm wondering if that's because it's become an international conversation, that's going to change. And
Yeah, I think it seems to be. The other thing that I will say is that anecdotally, again, I spend a lot of time with the American Bar Association and Labor Employment section, and both employers and employees are saying, plaintiff and management side attorneys are saying to me that their clients are settling more quickly and for more money. So to whatever that means, and I'd love to hear what others think about that.
so unless anybody else has anything on the panel to say, I'm going to turn it over to Gary Friedman.
Good morning. Commissioner Burrows is a tough act to follow, but I will try. Since I cannot see the PowerPoint, just give me a hand signal if there's a malfunction. Just be the third base coach, just wave at me and we'll get it fixed. I've got about 20 minutes to speed PowerPoint. A lot of slides. You have the soft copies. No way we can get through all of it, but from the national to the state and the local, I'm going to be dealing with the state and the local. As I'm sure all of you know, New York State has already enacted, and New York City has enacted, but it will become effective in April of next year, legislation with respect to sexual harassment, which we're going to talk about. And much of what the legislation is focused on addresses some of the themes that Commissioner Burrows identified in her opening remarks. It's really about training, consciousness raising, encouraging people to come forward, and New York State in particular has done quite an interesting job in telling employers how to do things, getting down to some fairly granular levels. This is how you conduct an investigation, taking what I think for many employers was two-dimensional and trying to make it four-dimensional. So I want to walk through some of those legislative changes. Just real quickly, as you can see, I mean, there is a movement, let's see, about 125 bills have been introduced across the country, and 11 have introduced some form of legislation addressing issues pertaining to sexual harassment, and it's growing constantly. Before, New York has really set the table on gender issues. I'm not going to spend time on this slide, but as I'm sure you know, there's the Cuomo legislation addressing various gender pay issues. There's also prohibition on familial status, which is not a formal protected classification under Title VII. And then, of course, there's the ban on inquiries with respect to salary history. So that's sort of the lead up. So in connection with the state law, this was done in connection with the 2018-19 budget. As most of you know, at the heart of it, there are issues pertaining to a ban on pre-dispute mandatory arbitration agreements, non-disclosure agreements, and then implementing rules and guidance with respect to training and policies. One thing it does do, it also extends liability for harassment of independent contractors and non-employees, so that's something to be mindful of. And this is an overview of the city law. The city law covers at least much of what the state law covers, although interestingly enough, and we'll talk about it, and it's in one of the later slides, there is a requirement for training of what they define as independent contractors, which frankly are individuals who work for a business for 90 days in a calendar year, and frankly about 80 hours, which is about 6 hours a month. So you may have individuals who are not W-2 employees who have some real glue with the organization who are going to have to be trained beginning effective April of next year. Just a couple of other notes. The statute of limitations with respect to the filing of harassment claims has been extended to 3 years, and issues with respect to protection of gender-related issues as it relates to harassment now applied to employers of all sizes. So, NDAs, obviously that has been a subject of enormous conversation, particularly over the last year. As I'm sure many of you know, as part of the Trump tax legislation effective at the end of last year, and I think beginning in 2018, Senator Menendez introduced 162Q, which disallows any deductions for any settlement or payment related to sexual harassment or sexual abuse if such settlement or payment is subject to a non-disclosure agreement. You can't deduct attorney's fees related to such settlements either. There's no definition, frankly, of any of the terms of harassment, abuse, non-disclosure, and it leaves open the question, and this obviously is a big issue when we talk about it under the state law, as to what happens if it is the complainant's preference that there be a non-disclosure agreement. So with respect to the state law, the presumptive prohibition against non-disclosure agreements relates to any claim the factual foundation for which involves sexual harassment. And then it sets in motion a three-part process. If it is the complainant's preference that there be a non-disclosure agreement, in that instance, all parties have to agree, but this is kind of an interesting process, and I think I urge you to read the FAQs on this one because it's not obvious from the face of the legislation. So the way this is supposed to work, at least according to the FAQs, is that you have to give, and they borrowed at least in part from the Older Worker Benefits Protection Act, you have to give the complainant 21 days in which to consider whether she wants to enter into a non-disclosure agreement. My understanding is, and this is very different from the Older Worker Benefits Protection Act, 21 days, is you can't waive it, you can't shorten it. You have to wait the 21 days and it has to expire, at which time, if the complainant's preference is to enter into a non-disclosure agreement, then it has to be memorialized. And it has to be memorialized, the FAQs say, in a separate agreement. So there is a separate agreement to enter into a non-disclosure agreement. And then, after that agreement is executed, the complainant has 7 days in which to revoke the agreement. Now, I've underscored and bolded various language here. It's unclear as to what can be revoked after the 7 days. As you know, under the Older Worker Benefits Protection Act, you can revoke the entire agreement. The way this reads, it seems to read that you can revoke the agreement to go forward with a non-disclosure agreement, but not necessarily the rest of the settlement. So that's very unique, and it is very different from the way the Older Worker Benefits Protection Act 21-7 works. And so these are some of the open questions. Obviously, what is the factual foundation of which? I mean, this is going to be a big issue for employers, and particularly in New York, where the city law is decidedly broader than Title VII in terms of its definition of what constitutes sexual harassment. We'll get to that in a couple of minutes. And then what do you do with mixed claims? Sex harassment, sex discrimination, disability discrimination, all in one action. How do you handle that? The only reason why I have an overview of the definition of sexual harassment is to just illustrate the difference between Title VII, everybody's familiar with the severe and pervasive standard. New York State pretty much follows Title VII in that regard. But then there's the city law, in which the standard, and the seminal case is the New York Court of Appeals case in Williams, is that he or she has been treated less well than other employees because of his or her gender. And I think of great significance here is the quote in the sub-bullet. The court found that the severe pervasive standard too restrictive because it sanctioned a significant spectrum of conduct demeaning to women. So if you're an employer and if there's a complaint of mistreatment, discriminatory treatment toward women, I'm being excluded from meetings, I'm being treated in a condescending manner, I'm being constantly interrupted at meetings, that might not immediately come to mind as sexual harassment under Title VII, but it might fall into that basket under the city law. And so this is something that employers need to be very mindful of. It raises the question, whether anyone at this point should be asking for a non-disclosure agreement. I'm sure we'll have a zesty discussion on that with the panel. Just to illustrate this, some of you may have been aware, a couple of years ago, there was a jury decision in the Faruqi and Faruqi case. It was a partner and an associate who were involved in some sort of relationship. And the jury, what's interesting about this case is the jury managed to thread the needle and understand the difference between Title VII and the city law. In that instance, the jury found no sexual harassment under Title VII with respect to, there was a holiday party that had gone awry, where the jury said that what happened after the holiday party was not unwelcome by the plaintiff. But then there were a couple of other instances, one instance in which the partner tried to kiss the associate inappropriately, and then there were a couple of instances in which the partner made off-color jokes. The jury said no liability for that, no sexual harassment under Title VII, but yes liability under the city law because in that instance the associate had been treated less well on account of gender. So that illustrates what we all need to focus on in terms of non-disclosure agreements. when claims are made, and particularly informal claims. I mean, if there's a complaint filed, presumably the count would indicate whether it is in fact a sexual harassment claim. But most of what we deal with all the time are internal claims or claims prior to any formal filing. Arbitration, that's another big part of this. So there is a ban on mandatory pre-dispute arbitration, resolve any allegation or claim of an unlawful discriminatory practice of sexual harassment. It does not apply to non-sexual harassment claims, and it only applies to pre-dispute arbitration agreements. And then, of course, the exception is except where inconsistent with federal law. So a lot of people may have been scratching their heads and saying, well, what were they thinking in the wake of Concepcion and Epic Systems? How does this apply? That's a good question. So there's no definition of sexual harassment as it relates to the arbitration provision. Obviously, the question is that ban preempted under the Federal Arbitration Act? And what do you do, again, with mixed claims? So just a slide on Epic Systems. I think everybody is probably familiar with it. I would also draw your attention to the last bullet, which is from Concepcion, which seems to address the issue. When state law prohibits outright the arbitration of a particular type of claim, the analysis is straightforward. The conflicting rule is displaced in the FAA. So the question remains, well, what does this mean? Does this have any teeth to it? Now, you can enter into an arbitration agreement that is governed by New York law. And as long as it does not implicate interstate commerce, then that ban would be effective. But in most instances, the arbitration agreement that parties enter into probably would implicate interstate commerce. And if it does, it seems it's going to be difficult to get around Epic and Concepcion. As I'm sure all of you are aware, notwithstanding that fact, there has been quite a growing movement to actually ban mandatory pre-dispute arbitration agreements for sexual harassment claims. Legislation introduced by the Democrats in October and November. 50 U.S. law schools calling on law firms to take a survey about it. The ABA calling on law firms to end mandatory arbitration for sexual harassment. And then the Google walkout, which I'm sure you're all aware of. Microsoft, Uber, Facebook, and Google are all going to ban mandatory pre-dispute arbitration as it relates to sexual harassment claims. Got about 5 minutes or so, and I'll just go through these quickly. Training. The training requirements are really designed to put meat on the bones. Many employers didn't train at all, which wasn't great, but I think the notion was that a lot of employers just go through the motions. It's sort of an empty, vacuous experience previously for employees. And they want the training to really be meaningful. They want it to come to life. And therefore, it seems like they spent a lot of time trying to identify what works. And presumably, maybe they dipped into conversations with the EEOC in terms of what works and what's effective. And so therefore, in terms of policies, they want policies to become more robust. I think most employers have probably policies on the books, but you really need to take a look at your policies again because there are some very, very specific requirements with respect to that. And I've also identified the website that you can access to get more details. Here's something interesting, a model complaint form. I don't know, some employers have complaint forms, but many don't. And they have policies that tell people what to do and where to go and who to speak to. This requires, the New York state law requires an actual complaint form that's pretty descriptive. Not only the description of the sexual harassment, but also identifying in writing potential witnesses, a question on whether the complainant has previously provided information, and a question as to whether they've already retained counsel. In terms of the training, training under the state law, it was as soon as, it was 30 days, and they changed it to as soon as practicable for new hires, and then you've got to train annually. And you can create your own cycle, but you're going to have to make sure that the training is regular, it's documented, and that it is interactive. And they're very specific about what is and is not interactive. Last bullet on that slide, you can see what the state considers non-interactive. I'm going to skip the city notice requirements. And I mentioned the independent contractors as it relates to the city. Just take a look at the sub-bullet. That's quite interesting. That's something that many employers might not be aware of. And just a final word on internal investigation. It's interesting that the state has a very concrete view on what constitutes a proper investigation. It's got to be comprehensive. It's got to address every allegation. Should be done within 30 days. They got very specific, and they didn't need to get specific. And they also say, don't stop there. Make sure you're reviewing documents. And they also say, you got to write up the results of the investigation. Again, a lot of those things were really left to the discretion of employers. And by the way, these are not mandatory. They're strongly suggested. But there are other slides. I am out of time. They cued the music, and I'm sure we'll be talking about some of these issues when we get to the panel discussion. Thank you.
Thanks, Gary. I'm now going to turn it over to Erica and Chris, who are going to give a joint presentation.
Yeah, thanks. So I think the way we're going to talk about this is, in line with what Gary was mentioning, there's obviously a lot of things that are coming up in terms of requirements and compliance requirements and making sure we're operating within each state's laws or city laws. But then what Chris and I also want to talk about is what I would call a groundswell of different movements and activities that, for me, have been happening around the world that have just really confirmed for us that our strategy of increasing diversity and making sure that we have an inclusive work environment are just even more vital to our company's success. And we're going to spend some time talking about that as well, because I think that that really is going to help hopefully solve some of the problems that we've been talking about today. So when it comes to some of the things on the ground that we've done, obviously the training, looking into our training, updating it, making sure that it is going to comply with New York. We always had different trainings, for example, in California, making sure, every state has, or Connecticut has some different laws. So we've always been very good about making sure that we were complying, and this just means more, making sure that we're doing that. The one thing that we did do proactively is we have an ADR program. It's a 4-step process, 2 of which are internal. Next is mediation and then arbitration, and we have amended that to make any claims of sexual harassment voluntary if somebody wants to arbitrate that. They don't have to. So that was one change that we did make in light of the different cases and state legislative movements. In terms of investigations, we have always taken it very, very seriously. We have a zero tolerance policy and have taken action when necessary. We do have leaders that make sure that that's very clear. We have a code of conduct that we make sure our employees are signing every year. It's always been something that's been part of our DNA. We've done integrity training. I've traveled all over to make sure that managers outside the U.S. that have U.S. employees understand the U.S. laws and the nuances, of having employees in our country. It's always been something that's very important and been an area of focus. So I wouldn't say that we've done anything different in light of Me Too, other than to just continue making sure that our HR department understands and knows how to do good investigations, and that we continue to make sure that our employees are aware that they can bring complaints and that they will be taken seriously. So Chris, I don't know if you want to add to that.
Yeah, good morning, thanks for having me. This is the movement, I would say, has given us the opportunity to really take a hard look at our processes when dealing with any type of complaints, including sexual harassment complaints. We're a larger company with a lot of resources, so fortunately we felt that we had, a very strong process in place. Nevertheless, though, from the top down at the company, we wanted to make sure that that everything, that we were dealing with these type of issues appropriately. I haven't seen, that being said, we haven't seen a change in the number of complaints that we've received. But we received back around the fall, this time last year when the movement first started, a couple of very old, like 25-year-old complaints that we received one through social media, others through direct letters to senior executives. Like any complaint, we would deal with it, regardless of the fact that it was dated. Actually, in one case, the accused had passed away. I don't think in any of the cases anyone was still employed. But some things that we've tried to focus on in a case like that, where we'll do our best to, we'll get in touch with the person who got in touch with us, find out what we can, if there are any documents or anything we need to look at. But also, our company is structured in a way that we have certain corporate hubs, but then we have facilities all over the country, essentially. And they are locally managed, and we don't necessarily have HR present there. So if one of these would originate from one of those places, we'd go in, we do what we call a climate assessment, and we just make sure that the climate there is one where people are comfortable bringing complaints and there are no issues to address. So that was the way we dealt with some of those older complaints that I don't think had Me Too not happened, we wouldn't probably have ever heard of those. In one of the cases, the individual was pleased, and she had just opined sort of on a public website about, yes, Me Too. I was also, it was a website that was a Pitney Bowes, Friends of Pitney Bowes or something like that on Facebook. So I don't recall how we generally, how we became aware of that, but in any event, we followed it up, and turns out she was letting it known that she had been a victim, but was pleased with the way that the company handled it. Nevertheless, we would look into those. With respect to investigations, one thing that we reaffirmed with our HR team, we and our legal team with our HR team, is these things need to be elevated immediately when you become aware of them. And again, that's a challenge for us sometimes when you have these facilities that are, there's not necessarily HR sitting at all of these facilities. So we want to learn of these as quickly as possible. And I do think that we've been successful in that, in getting that done, because we want to make sure that the investigations are handled appropriately. And also, I think it's important to get multiple perspectives when you're investigating these things, particularly when it's a credibility determination. It's never enough just to interview the accuser and the accused. We'll probe, we'll try and find other witnesses, we'll look for documentary evidence. So we're always trying to, but I think having multiple people get involved early, it makes it easier for us to make sure that the investigation is handled correctly. One of the things I would say, and this is kind of building off what Commissioner Burrows said, is, and the question that Davida had about the credibility of accusers out of the gate. There's nothing formal, but I do think that probably, you maybe start with a presumption, frankly, of that they're being credible. And I think in the past, high on the list of credibility would be, why didn't they bring the claim until now? I don't think that issue is important anymore. And I think the movement has definitely educated all of us, very well as to why there's a delay oftentimes in these complaints. So I don't, there's nothing formal in the way we investigate, but I think there's kind of a mindset there that, whereas maybe before that would be the first question on somebody's mind, it's not anymore. We're just getting into the facts, and we're doing the interviews, and we're trying to find out what really happened here. Like Erica, we have an ADR program, similar structure, multiple processes. We haven't frankly, I think it's been very successful in resolving claims generally. So I think the benefits at this point to us, we think, are present. And we think it's an effective vehicle to frankly get the parties sooner, oftentimes in a room together, and try and resolve differences than the courts perhaps would allow for. So I think that's, you want to take
Yeah.
the next issue?
Sure. Yeah, so as I mentioned earlier, you know, Chris and I talked a little bit about this and said, you know, we probably in terms of things that we've done, nothing that dramatic other than making sure we're being compliant and continuing to keep it as serious as we had. But one of the things, and I mentioned that, you know, I work for a global company, and while, you know, we have Me Too going on in the U.S., and that definitely has hit all over, I can attest to that. But at the same time, you have the UK being very vocal about disclosing pay equity, pay equity and making sure that we're disclosing what we pay. And at the same time, in parts of Europe, different countries in Europe, there are female director quotas, if you will, on boards. And so if you take kind of all of these things together, really what they have confirmed for us as a global company is that our strategy of trying to increase our diversity, particularly at the top, as well as ensuring that we really do have an inclusive environment, it's really just a confirmation that we need to continue to do that, and that it's even more important now than ever. And that's something that I'm quite proud of my company and what we've been doing to try to improve in that area. It is something that we measure our executives on. It is something that our executives are quite vocal that they want to improve. We have certain requirements that we have to do in terms of disclosure for pay equity, but we also do our own analysis, using consultants every year. It is something that we think is very important that we be looking at. We have networks, so we have women networks in many of our different offices in different countries that are quite active on international, just for example, on International Women's Day, we did a program globally with a woman named Barbara Annis, who is known for writing a book on gender intelligence. So we've sort of taken, tried to instill some of the things that she talks about with our employees across the globe. We are a member of the Center for Talent Innovation, which is Sylvia Hewlett's think tank on diversity. We do some work with her, and we've had her and her, for example, we had one of the people who works with her we did another program on National Coming Out Day across the country. We have also networks for LGBTQI. We have a huge ally group that is very vocal and active and has many senior executives as part of it. We really have been focusing quite a bit on unconscious bias and doing a lot of training on that. And hearing you talk a little bit about some of the cases where interrupting people, that really is some of the things that we've been covering in our unconscious bias trainings. We use technology. So we have Textio, which is a technology that allows you to put in the words you want to use in a job description, and it tells you if the job description is gender neutral, to make sure that when we're posting our jobs, that we're attracting a diverse candidate slate. We have diverse slate requirements. We make sure we have diverse panels that are interviewing. And we have won awards for our own The Way You Work program, which is a flexible work program, and that we've implemented globally. So, I think it's safe to say that we, and we also measure a lot of this. So, for example, we do an employee engagement survey every year, and it asks questions about diversity and inclusion. And, we have many actuaries at my company. It's very important that we look and crunch numbers, and we look at this every year very closely, and we are in the high-performing category when it comes to that. But that's, due to hard work and making sure that our employees really know that this is an inclusive environment where anybody can come and work and feel comfortable. So for me, that's, I think, really, out of Me Too, I think where a lot of companies are going and moving towards, and I think that's really taking it to the next step.
Yeah, I think if I were, I think I would echo a lot of that in terms of what our company is doing, and has done traditionally in terms of diversity goals, pay equity analysis. And one thing that we have a women's network as well, which is open to all, but that's a group that's trying to provide women with an understanding of various career opportunities for them. And that happens to sort of coincide with, we've really revamped our career network, our career development network, to try and empower people to sort of take control of their own career. And that's not as a result of Me Too, but it happens to coincide with that. But I think the two work nicely together in terms of us addressing diversity and inclusion and making sure that all, including the women employees, feel like they can control their own careers. Again, like frequent training and speakers as well on the topic is something that we commonly make available to our workforce as well. And an important piece for us is our corporate, from a corporate top-down level, we look for diversity as well, but as I explained as well, in our individual work sites, these are larger facilities, we've tried and successfully strive for diversity among those as well. So these are general managers of facilities, so they're essentially running their own businesses across the country. So we have a woman is the head of that business, and she has looked to hire women and minorities in those positions as well, and we have a lot of that. And frankly, that workforce is our most diverse workforce, so I think it's important to have, obviously, diversity among the leaders in that business as well.
You guys have plenty more time.
Oh,
We do.
I mean,
Is there anything?
maybe we could open it. I
Is there
don't.
anyone on the panel wants to
I have a question. You mentioned the kind of zero tolerance for sexual harassment, and sexual harassment is on a spectrum. And part of my experience in representing employees and hesitation that employees have around going to HR and reporting is concern about, well, if it's not something that's an assault, and it's something that's more in kind of the gray area of, it made me uncomfortable, or it was, maybe someone hugged me and I wasn't really sure. They don't want to report it because they are concerned about the penalty being harsher than the event. And so that becomes kind of a check, and I'm sure as an employer you would want those things to be reported so they can be addressed. So how do you balance kind of those dual concerns, messaging we're not going to accept or permit any sort of sexual harassment, and also messaging that you are going to be appropriate in how you handle matters and in a way that incentivizes people to step forward?
Yeah, I mean, it's a difficult question, right? I mean, what I don't know, I don't know. So if people haven't come forward, and they don't feel, it's hard to know that something's going on to address it. I think all we can keep doing is really just focus on trying to get that speak up culture, right? Where people feel comfortable reporting something because it could be addressed immediately as opposed to festering and becoming something much worse. But if somebody doesn't, I can't force somebody to come forward, I can't know. But, I think that just continuing to show that it's really important to us, with making sure that we're clear about our policies, doing code of conduct training, doing the kinds of trainings that we do. I mean, one of the things that one of the CEOs in my division, right after Me Too, during his town hall, just got up and started talking about, he's like, I'm going to address the elephant in the room, and I just want everyone to know that if you have a complaint, we really want you to come to us, and we want to know about it, because we can't do anything about it unless we know about it. But obviously, those are real feelings that people have. I can't, other than just you know, not having examples of where somebody did come forward and then what was actually retaliated, which, you know, it's really hard to balance.
And one of the things, I think that's an issue that comes up actually a lot, and one of the things that I was struck by when you were sort of describing, both of you, Chris as well, describing the things that you're proactively doing, is that that's related to this conversation because it's another way that you signal. Remember, I feel strongly, top of the agency has to signal that this is not going to be tolerated. Well, if you're doing all these other things to make sure that you are inclusive, that you're supportive, that you are paying people fairly, it gives the message, it underscores that message of what's not going to be tolerated. I do think one of the things that's useful is when employers talk about and are transparent about the fact that there is due process and there's proportionality in terms of, okay, if we get a report and we do our fair investigation first, that the investigation will be fair, right? And so being transparent about that as well. And that there's proportionality, you know? We're not gonna give you a slap on the wrist if there's a sexual assault, but at the same time, we're not gonna fire you for an off-color joke.
Right.
And so that there's some awareness, you know, you can't conceive of every possible scenario, but that there's some awareness of that there's some sort of reasonable proportional scale here, because that will encourage both, you know, people to come forward, you know, because most people just want it to stop. They just want it to stop. They're not trying to get people fired. They're not trying to ruin people's careers. They just want peace, right? And on the other hand, it allows, you know, the rest of the workforce to feel confidence about that as well. Because one of the things that I didn't talk about, and that's really important here, is that you want other people, you want bystanders to, right? Because it's sort of like the playground bully. Like, and so even if people are not witnessing exactly what happens, people kind of know after a while, right? There's a guy with the mistletoe and the Christmas party, extreme example, or the holiday party, extreme example. But there's people kind of know, or they at least see people being upset, and it's very distracting. And guess what? You're losing money over that, right? So if the bystanders also feel empowered to report, then you've got a win-win, right? Because that person feels they personally have less at risk, and if they think the system is fair and you're going to do a fair investigation and be proportional about whatever you find, they're going to help you too. They're going to bring these things forward, even if the individual, you know, person who's been targeted doesn't feel comfortable.
I think it's even more important to have multiple avenues through which to bring the complaints, which we have, and I think, you know, employers all should have. And in our case, you know, you can bring it locally to your manager, you can bring it anonymously through email, through a phone line, you can bring it through directly to legal, you can bring it to a team we have, which is our global ethics team. So all of those avenues are available, but the key for us is what are we doing with it, right? I mean, that's the key, and we have to take all those claims seriously. We have to, you know, consider not putting somebody right back in that scenario, you know, with that manager or whoever, after they've raised the complaint, even while we're investigating. We have to, you know, take things like that into consideration, because it's unfortunate, but even with all of this education about Me Too and all of those multiple avenues of complaint, there's no question that there's still going to be a hesitancy to complain, unfortunately. And, you know, hopefully anything I can learn today will help, you know, make it a little easier for folks. But what we do, again, is let's say, talk the talk by telling everybody all of this, you know, having the policies, describing what's unacceptable in there, and it goes beyond, you know, the legal definition of sexual harassment, making those phone lines and all the other things available to them, but also walk the walk in terms of, you know, if they do raise it, following up.
Yeah, Kara's question is an excellent one. I get asked this by my clients all the time, and that's where the training becomes so critical. What does zero tolerance mean? Well, you should have zero tolerance for sexual harassment, but should you have zero tolerance, if the definition of zero tolerance is the nuclear option, you're blown out of here. Should you have zero tolerance for inappropriate workplace behavior? That's the distinction. And that's where the training has to be. That's why I like what New York State has done, because if you make this interactive, you're going to have a session that plays out various vignettes across the spectrum of conduct. And what you're trying to do is you're trying to encourage the lower level conduct to be reported, but you're trying to encourage people to do it by assuring them that we're going to be proportionate in our response. And I think if you don't train people along those lines, they will have the fear about the lower, it's the broken windows theory, that Giuliani talked about. It's those low-level issues. If they're not reported, you're going to have the bigger crimes. Here, if you don't encourage people to come forward with the lower-level items, then you're going to have bigger problems. But that's where, well, we zero tolerance. We will not tolerate any form of sexual harassment at this company. But in terms of inappropriate behavior, these are the different ways in which we can possibly handle it. There's an interesting case, slide 31, maybe some of you read about it. An editor at PBS NewsHour was terminated without an investigation because apparently he was looking at a photo with a coworker of Meghan Markle, and he apparently uttered under his breath, quietly, "Not bad." Fired, gone. And does that warrant the nuclear option? I guess we can have a debate over that. So he sued, and he said, well, hang on just a second here. Okay, first of all, the women in our office are always talking about Prime Minister Trudeau and how hot he is. Okay, nobody's getting fired for saying that. It engages in sex stereotyping. And frankly, they didn't even investigate. They didn't even find out what the context was in which I was saying it. That's an example that could actually be used in a training context where you have to be proportionate in the way you handle the issues.
So I have a question, I guess, for Erica and Chris. I've had clients come to me and tell me that they were terrified of reporting sexual harassment, and they went to HR, and they asked HR to keep it confidential. They didn't want it escalated. And that's happened a number of times, and I've seen various different responses from HR to that. And so
Yeah, no,
can you speak to
that is a difficult situation that HR often finds itself in. Whenever I was training, when I was, prior to my role now, I was the head of HR for the U.S. And for my team, we would talk about this. And, really the answer, and we're very clear in our policy, is it's on a need-to-know basis. So we can't really promise you full confidentiality because we have to do something about it. And we, talk about different ways that we can have that discussion with the employees. And it's a hard situation because a lot of times that does make people very uncomfortable to really talk about it. And we try to, really make that real for them and what that's really going to look like. And so, we kind of talk to them about what the investigation process would look like and what we would need to do and all the steps that would be involved. But we can't ever really promise full confidentiality. That just doesn't work for us. So it's a tough situation because somebody could say, fine, then I'm not going to talk about it. And we've tackled that too in other ways. So when that has come and we don't know what it is, sometimes we'll do kind of what I would call like a culture pulse check on the department, something very kind of low key, just to get more of a sense of what's going on in that department if we can figure anything out. But it's very hard when we can't get the employees to talk.
Right. Right, a similar approach for us in that we would have that extended conversation. But same with you in that we may take the approach of a climate assessment survey where we're just asking multiple questions about the work site and maybe getting down to whether there is anything like that they've seen. I mean, that would be one other approach, but probably more commonly, I think, educating the individual about, a need-to-know basis, and I think generally we'd be successful, that they would.
Part of the implication there, right, is that the reason people don't want it to be escalated is because there's still such a fear and concern of retaliation. And I mean, I'm going to talk about it when it gets to my observation section, but that's something we're seeing still, retaliation. And it's something that the state laws and the city laws have addressed in terms of incorporating anti-retaliation policies into what's required and the training that goes with it. But what are you doing on that front to kind of assuage people's fears and also, teach and train about what is permitted in response to complaints of sexual harassment or any type of harassment, frankly?
Yeah, I mean, I think that is part of the initial discussion that we always have with the employee who's bringing the complaint, is that, you know, we need them to come, we don't, again, hate to use the word again, but we don't tolerate retaliation, and that, you know, we do, that is very important to us, and it is something that when we have the conversation with the person who has been, you know, accused of something, that we will mention there as well, that it's very important while we're doing this, you know, and you know, it's something that once HR, and we always have our employment counsel involved as well, that's something that we take very, very seriously and have to be very careful of. It's trickier than you would think because things pop up. And Gary, I'm sure you've seen it, but you know, sometimes it's a situation where there's a performance issue going on at the same time, or you know, it's often quite complicated, but it is something that we always look at. But again, you know, that these fears, it's hard, you know, just honestly speaking, HR can do a really good job of trying to make someone feel comfortable, but those fears are real and hard to overcome. Yes. Oh, I don't know, are we at?
Sure. We have a little bit of time before. Oh, okay. So let's turn it over to, let's save your question. We want to hear from you at the end, but we're going to turn it over to Kara.
Okay, so my section is observations from the employee side. So what have I seen kind of on the ground over the last year? And we didn't talk about it, Commissioner Burrows, but we adopted a similar format, except I'm starting with what hasn't changed instead of what has changed.
Go for it.
And what hasn't changed in the past year is that sexual harassment is still happening. You would think that with the exposure and the wide publicity that we wouldn't be having stories of sexual assault in the workplace, but we still are. And the stories themselves have not changed dramatically. You're still, you know, I'm still hearing on a very regular basis, if not an increased basis, stories of, you know, it's the drinks after work that turn into everyone going to a club and turns into the supervisor, manager saying, let's share an Uber home. Maybe that's changed. The rise of Uber means that it's more prevalent in these stories. And in the car, there's an assault. Or you get to the employee's residence and the supervisor, manager is insistent on following them up to their room. Still having the stories of, you know, conferences, workplace conferences where, you know, there's drinking and alcohol is still very prevalent in these stories. And, you know, someone follows someone back to a hotel room and there's an assault, there's sexual harassment there. Still stories among low-wage workers in the storeroom. You know, we are representing a group of employees at a fast food chain where it's just kind of the daily repetition of touching and suggestions and come home with me or I want to date you. Those stories are continuing, and you would think that the wide dialogue that we would have would mean that they are reducing in number, but we've not seen that. And what hasn't changed is that it's still overwhelmingly women who are subjected to sexual harassment. It's not limited to women. There's also instances of men who have been subject to harassment, but overwhelmingly it's still women in the workplace. And it's still also very much about inequalities in the distribution of power. And abuse of power. It's not only about that. Sometimes we're talking about kind of sexually predatory behavior, but it's also about this power dynamic, this inequality in power. So what has changed? I think the thing that I have been most astounded by is the number of women who have spoken up and gone to HR. You know, we were so used to, for so many years, HR, the employer, being seen as the last thing you wanted to do. And more, I have women coming to me having already complained to HR, and that is a shift. And in thinking about it, I've realized that part of it is a result of a demographic shift in the workplace. And you have women, millennials, and you know, I've gone to lots of panels on kind of generational differences in the workplace. One of the things that's so encouraging is that millennials who have been raised in an environment, women who have been raised in an environment where they've been told and taught and promised equality, come into the workplace and expect it, and expect that they are going to be treated in a certain way, and when they're not, report it. Remember, too, that this is a generation who came up through university at a time when the issue of sexual assault on campuses was prevalent, right? We're still dealing with that, but that was part of their dialogue. That was part of their national conversation that they have now brought into the workplace in a way that is pushing forward these issues and transforming these issues. What I'm also seeing that's changed is companies are in fact firing people who engage in sexual assault and sexual harassment. They're doing an investigation, and where it is in fact supported, they are firing people. And that is a difference, because we're talking about powerful people, people who make a lot of money. We're talking about rainmakers. We're talking about, the drivers of the business, and the employer is saying, we're not going to protect you. Where there has been, an issue of a sexual assault, you're losing your job, and that is a difference as well. What is also different is that, we'll get to that in a minute. There's also just shifting cultural expectations. And so I was sharing with some of my panelists earlier, I'm trying to find shows that I can watch with my older children. And we recently started rewatching this series, The Office, Steve Carell. And so we started with season 1, which was in 2005, and one of the first episodes was sexual harassment training. And for those of you who haven't watched it in a while, I commend it to you, if only to see how our cultural expectations have changed. It was unsettling at the time to watch that episode. He comes in and he's, what the workplace isn't going to be fun if we can't forward emails of monkey sex, and he brings in a blow-up doll to the sexual harassment training, and it's just like making crude jokes. And you watch it, and it was unsettling at the time because of the the disconnect that The Office was meant to highlight. But it's even more now, realizing, okay, we have progressed. That type of behavior would never fly. Both of you at the end would crack down on that so quickly, and the expectation is that that would never fly. And so there definitely have been kind of just monumental shifts in terms of what is expected and tolerated. I think, even if you look at how the Kavanaugh hearings were conducted, and you compare that to the Anita Hill hearing. I won't go into kind of the frustrations and the things that remained unsettling about that, but what was different was there was a very intentional dialogue about believing women, about not attacking women. And that is a change, even if there were still parts of that were so unsettling and so discouraging for so many of us. Another thing that has changed is that the Me Too movement is happening at a time in the labor force and the economy where the power dynamics are different between employees and employers. So if you compare to a decade ago, 2008, in the midst of the recession, a high unemployment rate, there was very little power in the employee's hands to negotiate, to dictate terms of employment, and that's changing. And so I see employees, first of all, saying, I should have the right to choose whether to stay or to go. For so long, as soon as council became involved in a discussion around sexual harassment, it was, okay, when is she leaving? When does she want to go? And more women are saying, why should I have to leave? Why can't I stay? Why should it be my career that is sent off track because of this? And I'm not going to. And they have, and employers are responding to that. So that is a shift. I've seen employees negotiating in their offer letter as part of good reason provisions. So good reason provisions are provisions that allow you to terminate your employment with certain rights and benefits if certain events occur. Things like a breach of the employment agreement, or a relocation more than 25 miles from your office, or a change in control, or certain other conditions. And a discussion around, if I'm subjected to harassment, if I'm subjected to retaliation, I should be able to leave and take my deferred compensation. I should be able to leave and take my stock with me. And so that is a shift, this idea, and there is now bargaining power and position to actually, effectuate some of these things. So that is a major change. Another that I've seen is around the issues of bystander reporting and manager reporting. The training that has been happening has been effective on many levels, and so I see women who are reaching out to their supervisors and saying, hey, this happened, how should I handle this? My coworker, said this to me, I'm not sure what to do, and the manager is saying, I'm going to report it. I want, letting them know and doing so, and a changed expectation around that. I'm also seeing bystander reporting, and this thrills me because I think one of the things that's very evident around any topic of discrimination or harassment is that you really can't legislate behavior. You can put laws into place that provide remedies when the law has been broken, but laws don't dictate behavior. You need to have a cultural transformation. You need to be creating a workplace of respect and dignity and inclusion for all your employees. And that is not something that the law can do. And so when you're creating an environment where you have men who are, first of all, speaking up in the moment and saying, wait, dude, that's sexist. What are you doing? Or, what are you doing? Get away. Or, you know what, come with me. Like, we're gonna ditch this guy. Who are intervening in the moment to interrupt the behavior. That's amazing. When you have observers, whether they be men or women, who see it happen and say, you know what, maybe she's not comfortable reporting it, but I'm going to. I went to the training, I heard that I'm supposed to, and I'm going to do it. And they do, that signals a transforming workplace, a transforming culture. And I'm seeing that, and it's exciting for me. What is upsetting is that there are still high levels of retaliation when a bystander reports. It can create an environment where, depending on the power dynamics and how successfully the workplace is transforming, where that person is now perceived as an outsider. What? You went and reported on us? You're no longer trustworthy. You're no longer part of the group. We are going to, and that person does experience retaliation. What is also very interesting, and Gary, I know you spoke about this, is what's happening on the arbitration front. And it's interesting and concerning at the same time. For this reason, we are seeing a pushback on forced arbitration. And it's a groundswell among employees, right? So you see Google employees actually walking out and demanding change. You see law school students saying, let's boycott this law firm so long as they have this arbitration provision, and that law firm capitulating and saying, okay, we'll not have this arbitration provision anymore. So it's something that people are starting to understand the existence of them. 5 years ago, I'd ask someone, do they have an arbitration provision? And they would say, what's that? What's arbitration? And people are now understanding, at least, that there is a concept of arbitration that they may be subjected to. And the reason it's come up in the context of sexual harassment is that arbitration provisions very, very often are tied and connected to non-disclosure confidentiality provisions. And so it's not only that you have an alternative forum for deciding or arbitrating a claim, it's a forum that is designed and often is dictated to be confidential, to be secret, to require that you not disclose the existence of the arbitration, to require that it not be open to the public at the proceedings, to require that there not be press coverage of it. It's a confidential proceeding. And while that may be favorable in certain circumstances, it can also have the effect of allowing bad behavior to continue on in a way that is detrimental to the workforce, to employees. And that is why these conversations around arbitration and sexual harassment are coming at the same time. Now, the concern for me is that it's not just sexual harassment, right? It's also race discrimination. It's also religious discrimination. It's also, LGBT harassment. It's retaliation. Those same dynamics that would suggest that confidential, private arbitration is not healthy for society or for the workplace apply in those other aspects as well. So I'm concerned that we're treating sexual harassment in a way that suggests that it's some unique or special situation and ignoring the very real, very important, very detrimental conduct that also should be publicly scrutinized and addressed in the same way that we're addressing sexual harassment. I think what's interesting with the New York law is that putting aside whether it would actually be enforceable under the FAA and in light of Concepcion and EPIC and other things, it is setting the default in a way that says, as a matter of public policy, we think these matters should be brought in courts as opposed to arbitration, unless the parties at the time the dispute arises mutually agree that they want to be in a private arbitral forum. So it's resetting that expectation. I think it's creating a means for employees in good faith to go into court and to bring these claims publicly, and it will maybe be litigated, whether it's an enforceable arbitration provision, but at least it will be on the public awareness chart. And I'm really curious what employer wants to be the employer to take on this fight and argue that it's unenforceable as a matter of law, when you have employers like Google and Microsoft and Swiss Re and others saying, we're not going to arbitrate these types of claims. We are going to allow people to bring these claims in court. What employer wants to be the one to say, oh, no, actually, we want to make sure that these are all private, confidential arbitration proceedings? I think as a matter of their public reputation, it's going to have the same effect, even not because of the legality of it, but because of what it suggests and implies in terms of what's important. I talked so much, I timed out of my notes. So one of the things one of the ways that this plays out is in the context of when disputes arise. I agree, with your statement that for most women, what they want is for it to stop. They want to be able to do their jobs free from harassment, free from discrimination, free from retaliation. They want to get paid. And they want to have a runway for career success. And so the vast majority of women, when they come to me, what they say is, I don't want a lawsuit. and that may be surprising for those who represent employers or management, but the vast majority of employees do not want a lawsuit. They want a solution. And when it comes to discussing a settlement, or litigation, it's because there was a breakdown in the process to address and remedy, and at that point, the employee believes there's no other way except to involve an attorney and talk about an exit or talk about a lawsuit, because we've not been effective in just making it go away. And because of the changes to the law, and I think more importantly, because of the change in public perception about what the law means, there's a much greater confidence of surviving summary judgment. So the New York City human rights law has always had, or at least since the Restoration Act, has always had a very favorable standard with respect to what constitutes discrimination. on Title VII, we do see courts kind of reevaluating what severe or pervasive means. You know, maybe severe doesn't have to be rape. Maybe it can be something else. Maybe pervasive, you know, means something different in light of the context that we are having. Maybe Farragher-Ellerth means something different in terms of the reasonableness of not reporting. And for those reasons, I think we're going to see a lot less cases going or being dismissed on summary judgment, and that drives settlements. Because if an employer knows, look, you know, I'm going to be facing this in court under public scrutiny, and it's not going to go away on a motion to dismiss or summary judgment, there's a greater inclination to resolve it at the settlement stage. What we see with respect to confidentiality and non-disparagement provisions in those settlement agreements is that there are more women who are saying, I'm willing to settle my claims, I'm willing to resolve my claims, and I don't want to have to be silent. And so we're negotiating much more around what can be said going forward. And sometimes, you know, the compromise is you're not going to name specific names, though sometimes the employer's saying, go for it, we fired the guy. If you know, we're not going to demand strict confidentiality. And sometimes, you know, there are other compromises where, you know, the woman can speak generally about her circumstances so long as she doesn't connect it to the particular employer. And sometimes it's just, we're not going to agree to a confidentiality non-disparagement provision. I have employers saying at the onset of negotiations, in light of the new law, we're not going to ask for it. We're going to take that off the table. We're not asking for a non-disclosure agreement. We're not asking for a confidentiality provision. I'm also seeing, particularly among financial institutions, that the templates for settlement agreements are changing to include carve-outs that are new. Carve-outs that say whatever the confidentiality and non-disparagement provisions are that you're agreeing to, you can still not just report to the EEOC, but you can report to anyone in management or to the board of directors. So we don't want to foster a culture where people feel like they can get away with it, it's going to stay silent. We want to make sure that there is a reporting mechanism internally where even people who have signed agreements can bring this to the attention of senior management and the board. So that is something that we've seen. And I'm seeing more women also who are taking advantage of the EEOC's push to make sure that they understand that they can never give up their right to file a charge of discrimination with the EEOC, and choosing, okay, I'm resolving this, but I am going to file a charge so that there's a record of it, so that, you know, there is some measure of accountability. And, you know, maybe the next person along the way will benefit, or maybe the employer will take it seriously, you know, with a charge of discrimination, or maybe the EEOC will look at it. So I am seeing people who are choosing to do that as a matter of principle, particularly around the sexual harassment area. So, you know, overall, I'm encouraged because, you know, there is a shift in terms of how employers are addressing this, how employees understand their role in this and their rights in this. I want to kind of touch on one other piece, which is what's happening in the legal profession. Because, you know, this is a problem in our own backyard. This isn't a problem in our own house. And it's still a problem in our own house. I represent many, many attorneys. And those power dynamics, the situations I described earlier, are things that happen in law firms. They can happen in in-house situations. And there is a movement. So you see, you know, the American Bar Association coming up with Resolution 302, which deals with policies around sexual harassment. The model rules of professional conduct from the ABA were amended prior to Me Too to include a provision, which New York already has a similar provision, 8.2, that specifies that discrimination in the practice of law is unethical. And so New York already has that ethical restriction that says that it requires that before the disciplinary committee can become involved, if there's a forum who has jurisdiction over that type of claim, so that you can bring a claim in court, you must first go through that process, and then a finding in that jurisdiction will become binding for purposes of the disciplinary committee. That's being scrutinized, that requirement, and because there is a dialogue that as a legal profession we need to do better, and we should be leading by example in a way that we have not. And so I encourage us to think not only about what this means for employees and employers generally, but what does this mean for us? And what can we be doing to be agents of cultural change within our own institutions, within our own firms, within our own companies, and really kind of get our house in order as a profession.
Thank you. So we have about 20 minutes for a panel discussion, and I have saved the first question for Professor Estreicher.
Thank you very much. I'm sorry I had to leave the first half hour. Terrific panel, especially found interesting Gary's and Kara's discussion of the New York State developments. Our earlier conference was on avoiding the next Harvey Weinstein. My experience is that for people who are not heavy rainmakers in organizations, this goes back even before Anita Hill, when I was advising companies, companies had low tolerance if they heard about the report of sexual harassment or sexual abuse. And if there's a factual basis for it, the person was eased out of the firm or thrown out of the firm in many cases. The problem is with the rainmakers, the heavy hitters. There, I think there is a disjuncture between sort of the HR policy of the firm, which ably represented by Erica and Chris. I mean, I think there's a conflict there at the point of the heavy hitters. Now, the New York State law tries to deal with it a little bit with the NDAs. I'm a little skeptical that's going to have a lot of practical effect. I think people that have terrific claims and are able to attract the Alden Golden firm, they have a lot of leverage for lots of different reasons, but I just don't see it happening. And you have very often first-time situations where the accused person doesn't have a prior record, where it is a kind of a credibility assessment. It's very hard to do. And sometimes it's the best resolution for both sides to have some sort of settlement agreement with an NDA. I'm a little concerned about making that a violation of public policy. I don't think a lot of jurisdictions will follow it. I could be wrong. So I'm not sure. But if something needs to be done, I think it identifies a problem, that if you have repeat players who are in fact doing this sort of thing, there needs to be some escalation of the company's response and the regulatory response. Now, I came up with an idea last year, and I'd like to sort of try it on the panel. The idea is to borrow an analogy from OSHA, the Occupational Safety and Health Act, which requires companies to maintain accident logs and report them to the Department of Labor. Now, an accident doesn't mean culpability. It doesn't mean there's been a violation of the occupational safety rules. It's a way for the agency to keep track of whether there is a systematic problem at the organization. So it's an analogy. The idea would be that the EEOC, I think it has the authority, although the Commissioner and I had a discussion about it, and she was a little bit doubtful about it, but I think it has the authority to issue disclosure requirements. And the disclosure requirement is we want to know if you are funding settlement agreements, more than one settlement agreement, that involves the same alleged, we have to have the right language, the same alleged individual. We want to know if you're doing that. And that would be sent to the EEOC initially on a confidential basis. But if it looks like there's a pattern, the EEOC comes in with a commissioner's charge and starts investigating. What's the purpose of this? The purpose of this is to stiffen the resolve of these terrific HR people like Erica and Chris, and stiffen their resolve in getting at the rainmaker. I think it can be done. It's not exclusive of other approaches, but it's something to think about. I was wondering if the panel has any thoughts on that.
Well, I would argue actually that the EEOC probably does have authority for some sort of reporting requirements. We have regular reporting requirements now for, at least for companies that have 100 or more employees. I think the Department of Labor actually requires that same demographic reporting for federal contractors as long as they have like 50 employees. So there is some precedent for reporting. I'd be interested to know what others think. I think that there's some value to having that because, you know, if you think about it, and this is the one place where I'd quibble. I don't know, maybe others do, of very many cases where there's actually harassment has happened and people are going to pay a bunch of money and there's only ever been one victim. I've never seen that case. Like people, I've never seen that case. I mean, and I've asked people with the EEOC, have you ever heard of that? Like when we actually find discrimination, you know, sometimes it's not there. But when it actually happened and it's a big deal and there's a significant sum of money, it's never, now sometimes they're timed out, sometimes they don't want to be part of our suit, but it's never just one woman. It's never just one person.
Well, it
who's
could be,
had
but there are
it
lots
could
of
be.
people
It
who
could be
get
the first
fired
time.
and disciplined, told to leave. Anyway.
Could be the first time it's reported to the company, for sure. And so how do they know? But, you know, I'd love to hear what others think. I don't, you know, I'd want to think about it more before I take a position.
Yeah, I mean, I guess the one thing that's coming to my mind that I'm concerned about is, you know, also thinking about the other side. And just because somebody does bring a claim against you doesn't mean that you've actually engaged in those
this is
activities.
for
And if we
settlement.
haven't,
This-
so this
at
would be
that point.
just,
For
but even
This would be,
settlement.
yes, the company funding a second settlement involving the same person.
Oh.
I think you have if that's true, your zero tolerance policy is a bit ephemeral. That's where I'm coming from.
Okay, so it's a second settlement.
Against the same person.
Against the same person.
Okay.
I mean, kind of relatedly, right, and the idea that I have seen the first-time offender, the first-time harasser, but yes, very often it is someone who has a pattern of behavior, and it may be that that pattern of behavior was at prior employers. And so I'm curious, you know, what types of efforts are being made at the hiring front to assess why someone was dismissed or left another company. Was it done in connection with complaints of discrimination or retaliation? Because I can tell you, you know, I know employers hate it when they find out later that this person was let go from 3 prior employers for the same sorts of allegations. So is that being considered? What's being done on that front? Or do you have ideas about what could be done on that front?
Make it discoverable in a litigation.
Yeah, I don't think we would, I mean, there's nothing particularly focused on that other than the normal, if something appears odd, you know, probing with the individual as to what happened, but not, I don't think anything more in terms of searching and the background in that respect.
I know some law firms have included, when there's lateral moves, as part of the questionnaire and the conflicts checked and things that you have to do, you have to disclose whether there have been allegations against you related to sexual harassment. And, you know, whether people answer that truthfully or not, it is something I don't think it's uniform by any means across law firms, but some law firms are starting to take that step when hiring someone laterally.
And of course, FINRA has been very comfortable with U5s, with that concept for a long time. It goes on your U5 if you're regulated by them. Now, obviously, there are lots of euphemisms that can be used, but you carry it with you throughout your career.
Yes, of course.
You know, on Wall Street, we've been hearing about these Weinstein clauses that are being asked about in merger and acquisition deals. Does that come up in your practice at all?
Very much so.
You want to explain what that is? I mean, I think I know what you're
Sure,
talking
so
about.
it would be sort of a morality clause where, I mean, I think Gary can probably address it better than I can.
Well, what we're seeing in the context of transactions are representations, and very finely drafted representations, other than the sort of obvious you're in compliance with all federal, state, and local law. You're getting down to the level of not only have there been no claims, but no one's complained of sexual harassment, sex bias, and you know, we're dealing with some pretty large companies in that regard. In the school of never say never, you have a pretty interesting discussion over those representations in the context of a transaction.
So is it becoming the rule rather than the exception to the rule?
It really is, I mean, over the last year in particular, I think it's some form of sexual harassment-specific representation is being requested. Although I thought Kara's point was very interesting. I've been scratching my head about what's so special about sexual harassment to carve that out from racial harassment or from sex discrimination. I mean, I guess the legislatures are making a decision, probably based on the drumbeat of events, that that's the most heinous form of violation. We could sit here for hours and discuss that. But it is very interesting, Congress too, it seems to be elevating that to a particular villainy that I'm not sure it should be ascribing to when racial harassment, sex discrimination, age discrimination, I mean, they're all at the top of the list.
So something that I've heard about in this past year is sort of an undercurrent of fear on the part of male executives who are kind of afraid to be alone with women, who are afraid to go on business trips with them. And it seems to me that this may open up a whole sort of new category of claim by women who feel that they are being left out of mentoring and left out of career opportunities. Does anybody have any thoughts about that?
I've had that case. Someone who was experiencing what you described in terms of New York City human rights law behavior, the standing over her shoulder in an aggressive way, undermining her, doing types of screaming at her in a way that he didn't with male colleagues. And she complained to him about it. And in response, he said in writing that he no longer felt comfortable being alone with her in a room. Mind you, she's a manager, he's her senior manager, and that going forward, there always needed, anytime she was to meet with any man, there needed to be an observer in the room. And so, yes, I said this is retaliation. It's its own form of discrimination. I think the concern is greater than the actual threat, in that, again, women are not like walking around looking for a man to like look at her differently so that they can bring a sexual harassment claim. I had one woman who was subjected to sexual harassment say to me, look, I'm a New Yorker. I know the difference between a man coming on to me and a man just like being a man. Like, I know that difference, and I'm not looking to come after every man. This man was different. And so I think, men need not be concerned that by virtue of being a man, they're a target. I think men also know when they are engaging in behavior that steps over the line, that is, meant to, or is sexual in nature, or is, treating a woman differently. So I think the concern is maybe overblown, but I definitely have seen that reaction.
I would, go ahead.
No, you go.
You sure? Okay, well, the one thing I would say about that is, we can argue, I don't disagree with anything you've said, but I have been hearing that too, that it's a concern, whether or not, it's out there. And one of the things that I've been hearing from some of the HR folks is that actually some of the people, it's a real problem for them, because obviously this whole mentoring thing is part of the way you get over some of these problems, and that in fact, they're worried. One in particular said to me, I'm worried because it's not everybody who wants to mentor, right? It's not everybody who's trying to do this. Our company, we're trying to change the fact that everyone at the top fits one particular demographic. We're trying to do something about it, and we've got some folks who are really superstars as mentors, but because they do so much of it, they feel very exposed, that someone's gonna say to them, why are you always taking her to lunch? Or why, they do not want that level of scrutiny. And I'm afraid I'm going to lose these 3 people who happen to be white men who are fairly senior, who are great mentors, because they don't want to, be in the position of excluding some people, but they also don't want to be asked why they keep taking these young female associates to lunch. And so one of the things that, and so it's a real kind of thing that people are wrestling with, whether or not they should be. And I think that one of the things that companies can do, and I'd love to hear reactions from others who are representing employers, is that to sort of formalize and institutionalize the mentoring so that it's not, you know, this is something that we do. And so the reason why we're going to lunch is because it's what we do, right? So that it's not just a couple of people who do that and it seems, and it's unusual. It's like there's a formal, whatever it is, mentoring program, and it looks like this. And maybe it's not lunches, but it looks like this. And so it's expected. And so it's not just a couple of people who are going out of their way to try and be helpful and do the right thing who feel like, well, we're kind of sticking our necks out here. But I'd, love to hear, Gary, you wanted to jump in on that?
Yes, so I think that's actually an excellent point. And again, this comes back to training. One of the things that's changed in my practice is at our particular price point, I normally don't get asked to train, but I am now being asked to come in as the scary guy to the C-suite and say, all right, okay, put your phones down, put your pens down, and let's learn here. Because this is different. You give them a different look. I'm not a consultant, and so part of that training involves the Mike Pence rule, which is I don't go out to dinner with anyone, not my wife. That's not going to cut it. And that's part of the training that you do with the culture carriers, the mentors, the supervisors, the managers, and you frankly go through scenarios where they're trying to, get out of, quote, potential harm's way is actually walking right into it. And so I think your idea is terrific, and we're seeing our clients begin to formalize this as part of the mentoring program. We expect you to be going to lunch. We expect you to be going off-site in an appropriate location and talking about careers. But I'm interested in what your perspectives are.
Yeah, I mean, actually, in the middle of all this, we did institute a sponsorship program at the very senior level. So it was our executive committee, our sponsors to female top talent, to be advocates for them, to develop a relationship that's strong enough that they can advocate for them in the, boardrooms to try to, help them further their careers. So I was concerned that that was going to come up and that I would get some questions about that. I haven't, but, I do think this is, you hear about it in the media, it's certainly, you can imagine, but we did formalize this program. We've had other programs. We do have mentoring as well. And we do have things, for example, in different offices where we'll do like a speed mentoring program where, you come in and you pick your mentor, and we have and it's very formal and fun, but also just legitimizing that this is important to us. So I do think that is a good way to get at it, but I think what, some of the things that you're talking about
A
are.
related question for the panel. What does the panel think of, in some circumstances, non-fraternization rules? Say, let me
I'm looking at Chris for some
Let me
reason. I don't know.
say a rule, let me make it more concrete, a rule that says, if you're a supervisor, you don't date people you supervise,
Yeah,
people in
well,
that category.
We have a rule like that.
And
in
if you
place.
do, we fire you. We fire you, the supervisor, or something like that.
Yeah, well, we don't, that second half isn't necessarily included.
Hopefully
but-
it's implicit, yes.
But we do have a rule, and I think it's essential to have a rule like that in place. And I mean, we have found it violated on occasion, and definitely addressed it. Usually, I mean, it does get tricky in terms of, do you move, who do you move, or do you move anyone, what do you do? But we, we do believe in that. And frankly, I was asking HR in advance of this panel, have we thought at all about, going further and having an absolute prohibition on any fraternization, not just within the supervisory chain? We haven't, and we're not really considering doing something like that, but you can see, because just being in the line of supervision doesn't matter, right? If it's a senior
Right, it needs to be
senior executive
better
and it's
defined
somebody
than
who's a
that,
subordinate but in a different business unit,
Right.
there's a whole host of problems with
And
that.
Erica,
so-
what's your company's?
Yeah, we have if there's any sort of reporting line, it's expected that you report it to HR, and we do what we can to maneuver any sort of reporting lines, obviously. But we don't have a no dating policy.
Thank you.
I like the reporting requirement because it removes the ability of that abuse of power dynamic that can fester in a secretive environment. So if the employer, if it's a legitimate relationship, and it's going to be reported, that's a different can of worms than the supervisor who's abusing his position of power, knowing that no one will ever know, and this person's not likely to report it. It kind of requires it to come into the light in a way that can also have a good effect in terms of stopping behavior you don't want.
It helps you resolve credibility assessments because they become immaterial. You had this relationship, you didn't report it to us.
Right.
Yeah. Let's talk for a minute about this new mandatory training, which is new for at least New York. It was not required that companies train their employees. A lot of companies did, but it could have been something like slapping up a video and having everybody in a room and watching it and having them sign an attendance sheet. Now it's required, it has to be interactive. What does that mean to you guys? I mean, I have my own definition of what interactive is, but.
Yeah, I mean, we already had, I mean, in a way, because we were complying with California and there's some really specific requirements there. I mean, we already were using, a vendor. It has the vignettes that are kind of, worthy of discussion. You can ask questions. It's interactive in the sense that you can ask a question, it will go to HR and someone will answer it. But I don't know if it, I know they're looking at it right now in terms of, obviously that vendor has to be compliant, so they're going to have to sell us something that does fit. And I'm sure all of the vendors are doing that. And there are several that are pretty good, because I way back when we picked this vendor, I looked at a whole bunch. But that's, what we've been doing, because we have people in so many different offices and even different countries. So anyone who has a U.S., report, we're trying to make sure that we're covering that, and then all of our U.S. employees, of course, have, there's different trainings, one for managers, one for employees.
I mean,
We're similar in that we use a vendor, and we'll continue to use a vendor. I mean, I don't think there's any substitute for in-person, it would be nice, but practically speaking, it's really difficult for us. If we find a need based on what's happening, I'll fly in. I'm not as scary as Gary, but I'll fly in, and I'll talk to the management team the employee population there. But that, because of practical considerations, we have it interact via some type of screen learning.
Yeah, I think maybe one way to look at it, live training can be very expensive, and particularly for large workforces. Maybe one way to look at it is break your workforce up into various levels and segments. Who are the ones that really can create the greatest havoc, and also who are the ones who are the culture carriers of your organization? Maybe those are the ones you train live regularly, and then you go with the interactive approach with other segments of the business. I think that you do have to look at it through a variety of different prisms, because at the end of the day, what's the goal? The goal is to make sure that you have a workplace that is, hospitable to work in. And you mentioned climate surveys. We're actually seeing companies now have anti-bullying policies, which has its own set of issues. But companies are really focused on climate, far, far broader than just anti-harassment, anti-discrimination.
One of the things I'm curious about is, as there's a lack of kind of comprehensive federal legislation and states are stepping into the void with state legislation, it seems like we can be creating kind of a two-tiered system within the United States, depending on what state you live in terms of your rights and remedies as an employee. For those with a national presence, companies, how are you kind of addressing that in terms of standardizing expectations across the workforce? Are you adopting kind of the highest standard for everyone? Are you kind of having different trainings based on where you are? How are you handling that aspect?
Yeah, so I mean, I would make an analogy to sexual orientation, right? So different states, different cities have, that's not under federal law, but we've always taken the most liberal interpretation, you know, and make that part of our general policy for the United States. So even though, you know, in a state where maybe they couldn't go and file a claim with the state Division of Human Rights, we would still investigate it, and we would still, if somebody violated our policy, would still deal with it that way.
And I should just add that the EEOC would as well. We have taken the position that sexual orientation and gender identity are covered as part of the prohibition on sex discrimination. So that issue is pending. There are a couple, actually 3 cert petitions now before the Supreme Court. We've got 2 with respect to sexual orientation. 1, our successful case out of this Second Circuit, and then the 11th Circuit has one that went the other way on sexual orientation coverage, and then there's a case on another one of our, actually, we're the plaintiff. We're amicus in one of the others, but we're the plaintiff in a case called Harris Funeral Homes that is, you know, sitting there waiting for the court to decide whether it'll look at that. I think we are correct, but most of you know that the Justice Department has taken a different perspective. But just, you know, since the issue came up, I want to be clear. If someone comes to us, we investigate those claims, and we feel that we have a duty to, because otherwise, you know, you can't file a private suit, you can't get anywhere under Title VII. And we have been, I'm happy to say, very successful so far. So.
Let's open up the floor to your questions. There are 2 microphones back there, if you want to use those. And just let us know who you are.
I can hear you. You sound terrific.
I have a very quick question. You've only been talking about corporate environments, but there was news about elected officials, and I have heard anything recently, so I was wondering if you could address that.
So that's a nice understatement. There was news about elected officials in this area. Yes, indeed there was. It seems so long ago, but like, you know, right about now, last year, this was top of, you know, above the headline, above the fold in just about everybody's newspaper. So I'm happy to say on that, let's start with Congress. This has been a big issue both on the national level, but a lot of state legislatures have had high-profile issues. And one of the things, since we've been talking about how reporting happens and can you have a system that incentivizes reports so that you can figure out what's going on, investigate, and get to the bottom of it, well, here's the deal with legislatures. And I can say this with respect to the Congressional Accountability Act for sure, and it, you know, like only anecdotally as to some of the states that have had problems, the systems are sort of, you know, without going into minutia, let's pretend you were going to sit down and come up with a system that would make it was not arbitration, but that there was going to be a reporting system so that nothing would ever pop out the other end. That there was a place to go, and then you put in all sorts of waiting periods. You know, let's sit around for 30 days and not do anything. And then underfund and understaff the folks that were supposed to get to the bottom of it. That's what the process for reporting, if you're a congressional staffer, is. And fortunately, I can say this is public, I spend a lot of time, the Congress is aware that this is a big problem. Because all of America knew it too. And I spent a lot of time speaking to folks, mostly on the House side, but also on the Senate side, about some suggestions for remedying that, as did my other colleagues on the EEOC. The House passed a bill, I believe it was in February. And the Senate has not put the bill on the floor, so that's kind of where we are. As a former Senate staffer, I'm very disappointed about that. But unfortunately, news media moves on. A year now seems like a long time ago, but it is still hopefully on their list. There was a group of women senators who sent a very strongly worded letter to the leader and asking for movement on the bill and put it on the floor, but that has not happened. So at this point, the fix for it has passed the House, has not passed the Senate. Obviously, you get to January, it's a new Congress, you got to start the whole process over again. But I do know that the Congress has been looking at it. Isn't that what they always say when it's not done yet? They're looking at it. And I know state houses are looking at it, and very seriously. So there's a lot of focus also from the women's groups, from the civil rights community on that issue. But one of the things, again, going back to, there's two things that are necessary, lead from the top. And what better way to lead from the top than for Congress to say, we're not going to have this anymore. We're not going to do this anymore. And particularly with the Senate, I mean, they've got the page situation still. The House did away with pages, but they've got teenagers in there. And there have been instances of harassment involving the pages. So I'm hopeful, but I'm not going to put money on it, that this gets fixed in the next Congress. I don't think it's going to happen this year. I think you're up.
Good morning. Marjorie Mesidor of Phillips and Associates. My question is part commentary and part question. First and foremost, I want to thank the panel. This has been a very engaging discussion, and I've certainly learned a lot. And the commentary that I had was around certain buzzwords that are a little bit too familiar to me, because I often hear them in cross-examination and depositions about zero tolerance policies for sexual harassment as I rip through the investigation process, where undoubtedly there was either limited or no investigation. Not besmirching anyone on the current panel, because I'm actually quite impressed with the level of diligence that our management side attorneys and management side have put forth to make reporting an easier process for employees. That aside, there is another level, because I also often see this sexual harassment from the reporting all the way through the resolution process like an onion. Another level of this onion of reporting is also what I find personally uncomfortable, is the level of evidence that a person who is accusing another of sexual harassment seemingly needs to bring to the floor to HR in order for their complaint to be taken seriously. I am disturbed by it as a plaintiff attorney. I'm disturbed by it by a woman in the workplace, that the amount of evidence in order for it to be substantiated, for anything to actually be done, is quite disturbing. And while I understand that anyone can say anything, I can say that we were held at gunpoint in this room, and it's going to be, through various testimony in our respective word as to whether or not that actually happened. I have yet to find the case where the harasser in an open room like this actually touched the person, made the inappropriate comment. It usually almost is exclusively he said, she said, and overwhelmingly I've had hundreds of sexual harassment cases, not an exaggeration. And I only can recall two off the top of my head right now where the complaint of sexual harassment was substantiated. And it is always because it happens in the moment, and unless you're walking around with a tape recorder at all times, or you're somehow able to have some text messages, which can happen sometimes, that you have text messages, but then the argument becomes, oh, it was consensual. Not that it didn't happen, but somehow it's consensual. And I'm disturbed by it because it frustrates me because I would prefer to be in another line of business than trying to level the playing field for workers. I would prefer to be able to use my talents doing other things. And while I can appreciate the heart of an organization to say that we have a zero tolerance policy, too often than not, I do not see that effectuated in these terms that we are coining and constantly using, that the people who are launching accusations are to be believed. The level of effort on the part of the investigator for it to be independent, for it to be fair, for us to not look at just what the person is saying, but to otherwise corroborate. The best case that I've ever had of sexual harassment, where it was a completely he said, she said against a particular organization. This organization went above and beyond and actually began to look at key card swipes and requests for emails and reimbursements, and did all this independent stuff. And they said, you know what? We believe her. This is wrong. We're getting rid of him. Do you want to stay? Do you not want to stay? And that really was the best result that I could have asked for. So, very long commentary, shorter question is, to what degree those of you who are at the panel are seeing this issue addressed? Have you seen it? Are you, what efforts and discussions are being had in regards to the level of evidence that is being required by the person who is making the accusation in order for there to be a substantiation? And a very quick follow-up is, when there is no substantiation, like I've seen in 90% of the time, why do we just put them back to go off and work together again? I feel like it's really the worst case scenario, and inevitably always leaves the person making the accusation looking for another job and leaving.
Yeah, no, I think, thanks for your comments. I think we try to, I don't think it's changed for us, but we always would look for other evidence. I mean, probably principally looking for other witnesses. We look at surveillance video. We have, some of the ones that are commonly, we would look at something like that. We'd ask whether there's emails or text messages like that. If we're left with, truly he said, she said, we just have to look at whatever, we'd have to make a credibility determination. And we'd have more than just one person involved in the investigation. I think multiple perspectives would sort of be brought in. But, I just, as a company, we wouldn't necessarily then say, hey, sorry, we found, we can't, we throw up our hands, we can't make a decision, get back to work. It just wouldn't happen. So, but it's a tricky solution though, because, okay, then what do you do? Do you move somebody? Do you change their shift? You don't want to do anything that's unwanted or retaliatory to the individual who brought the complaint. So I can't really give you a good answer other than all considerations, good issues that you've raised and things that we consider when we try and resolve these issues.
Yeah, I mean, I would agree with Chris. Any other information that we can gather, we certainly would go the mile to do it. We certainly do have looked at emails, door swipes, computer, whatever we can, if that's the case. But there are situations where there really is, unfortunately, nothing to help us, and that is a difficult situation. So I would agree.
And I've seen a palpable change in mentality from employers in the last year in terms of scoping of investigations. Remember, I think it's probably fair to say that the employment lawyers and the HR professionals have always been a few steps ahead of the business line because this is what they do for a living. Right. It's closing that gap, right? Because HR, at the end of the day, has to interact with the business line, and if the business line is saying, oh, okay, I get it, I know we've had this policy for 20 years, but it's different now, then what you're going to get is you're going to get the full-throated support for an appropriate investigation. So intent has been raised, scoping is broader. I think that remediation is going to always trail the investigation, because I think that society has got to get used to some consequences, across a spectrum. But I've also seen a change in that regard.
Thank you.
Are you ready for another one?
Yes.
My name is Carlin Meyer. I recently became counsel to the Assembly Committee that enforces our policy against discrimination in New York. And I have two quick questions. About 5 years ago, as someone standing next to me is well aware, the Assembly had some little trouble with sexual harassment and changed its policy. I am proud to say that we have a mandatory reporting policy, not merely for sexual harassment, but for every form of discrimination. But I am asking for help from the committee. We're in the process of looking again at the policy and how we can improve it. And one issue that has come up from the community of targets is that our mandatory reporting policy disempowers them. And because of the peculiarities of our workplace, which I will not go into, can be a very sensitive issue. So I'm looking for your guidance a bit more on how you empower targets at the same time that you enforce mandatory reporting? And my second very quick question is, at what point do you inform, in order to prevent retaliation, at what point do you inform the accused that there is an investigation being undertaken? At the moment, I should say, our mandatory reporting policy immediately triggers an outside and very thorough investigation. And that has an impact on the workplace, and it is for that reason that the persons who are targets feel like they have been tremendously disempowered, because outside reporters, if they call us, it triggers that investigation. If they don't, and there is a witness or anyone who becomes aware of the policy who is in a management position, then there is an immediate investigation. And that is always, because the offices are small, becomes a matter of public knowledge to some degree or another. So any help you can give us? And last but not least, are you willing to talk to us outside here about improving our policy? So please.
Well, I mean, I can say in terms of the accused, the individual, I mean, typically we will advise them, or the company will advise them at the outset of the nature and scope of the complaint, and also what we tend to do is we'll work with our clients about the process in terms of how you ultimately get to the accused. I mean, gathering the information, you know, people can conduct investigations differently. We didn't have time to get into that. If you're interested in what my colleagues to my left think about this, but putting the accused on notice early on and with a very strong anti-retaliation message, understanding also that there are confidentiality issues at play, but you know, you can't cloak everything in secrecy. So I think that's an early notice that occurs.
Just quickly, do you tell the accused the name of the, do you tell the accused the name of the target?
It depends. It really depends, because if you're not ready to, I mean, ultimately, first of all, some people come forward anonymously, but assuming that person does not, at the time of the interview of the accused, they have due process rights.
Sure.
And they're entitled to know who's making the claims. But at the initial point, it may or may not be a situation where you have to disclose who the complainant is. I'd be interested.
Yeah, I mean, I think it really does depend on the situation, but also sometimes it's going to be obvious the minute you say it. So whether you say the person's name or not, they're going to know who it is. So, I mean, that's just, but we also, I mean, try to tell the person early on. But like you said, there are some things that might happen behind the scenes that could be done without having to talk to anyone, just to gather some information. But we do try to tell them early on because, you know, it's important that they get a chance to tell their side of the story as well.
And on mandatory reporting? And I should say, by the way, that on our mandatory reporting policy, the issue, we are required now by state law, state agencies, and the Assembly must, and the Senate must have mandatory reporting. So what we're looking for is adjustments to the procedure so as to give maximum agency to the person who is the
Harlan,
victim.
can you just clarify your
Yeah.
mandatory reporting of all accusations? Is that what it is? To
And
to whom?
What our policy says is if you witness or become aware of any form of discrimination, you are required to report it if you are an administrator, a manager, or a member of the Assembly. So that's how
And
the
who do you
policy
report it
works.
to?
You have a couple of options, to me or to a hotline, to any member of our committee, and to the Human Resources
Thank you.
bureaucracy.
I
So,
think we have
any
time for
thoughts?
one more question.
I'm not sure we answered your question,
Oh.
but, I mean, I think,
It's okay, I'm happy to come up afterward and allow someone else to
Yeah.
ask a question,
Thank
so
you.
Thank you.
why don't we do it that way?
Thank you.
Thank you, Carl.
We have time for one more question.
Hi, thank you for the panel. My name is Ariana Tobin, and I'm a reporter at ProPublica. So I have a question. I'd love to follow up on that phenomenon I think Chris raised of people coming forward, 5 or 10 or 25 years later with a concern or a problem. Because as you can probably imagine, a lot of the people who are calling a reporter at this point are people who've gone through either the system in the employment context or in the legal context and had something that was settled in a way that didn't feel fair to them. Or especially, I think as we're culturally relitigating how a lot of very specific concerns get handled, like whether that's about confidentiality agreement or arbitration clauses, it was played out for them in one way, where they're looking around now and saying, people are starting to agree with me that this wasn't fair. So I'm curious if in a very practical way on all sides of this employment question, how you're seeing both employers and the legal system reacting when questions of enforceability come up on some of these things that may have been settled years ago. And to be a little bit more specific, I've had people where maybe years later, their employers are being really outspoken about we're trying to make life better for our employees now, but simultaneously sending very threatening letters to people who are considering, either speaking out in the media or posting online.
Well,
Looks like you've stumped the stars.
So I think what you're getting at is sort of the law versus the current reality. So when non-disclosure agreements were enforceable, and there were no issues, and now people are coming forward and saying, I frankly am very concerned, I was exploited at that time, I was taken advantage, I want to tell my story. Look, I think that in advising our clients about situations like that, you do need to approach it from two different perspectives. And it's really contextualizing what life was like 15, 20 years ago. We have this debate all the time in terms of bias, and you see what's happening. Obviously, there's a national movement to revisit people's views of the world, whether it's Woodrow Wilson or even Lincoln. You have to contextualize it, right? So 15, 20 years ago, the lens looked very, very different. The rules were very, very different. So to have an employer say, hey, look, I just want to let you know, did have an agreement, it was settled, it was resolved, we thought it was over. That's part of that's one part of the discussion. To get heavy-handed, however, and to say, to send threatening letters and communications, et cetera, that's a different story, and that's frankly not great advice, and I'm sure my colleagues here would not approach it that way. But by the same token, there does need to be a recognition that 15, 20 years ago was 15, 20 years ago. Doesn't mean the sentiment being raised is inappropriate. And I think you're going to have to engage in a dialogue, although I think you can see where employers that are dealing with something that they thought was over and done with, may be of a mixed mind in that regard. And so I think the advice has to be both practical and frankly legal in that respect. We know of some public official that's not handling it through the second chamber, perhaps as well as certainly my colleagues would advise, but there is a legal aspect to that as well. I don't know if you want to comment on that.
No, I agree. I mean, I think there'd be sort of competing opinions about a situation like that within the company too, like where we would have, a desire to say this is resolved and sort of stay out of it. But at the same time, I think if our position was presented in context and what, what life was like 25 years ago, it probably would be a better way to handle it. So, but my gut when you're first saying that would be, I would certainly not send a heavy-handed letter. That would just not be our approach. And just to be clear, that situations that we dealt with 25 years ago were not settlements. They were just, but yeah, I mean, I don't know if that kind of answers it at all, but I think there's multiple perspectives there. But certainly to, go after somebody and say, we had a deal 25 years ago would not, I don't think that's a wise approach.
And the only thing I would add on that is, it sort of depends if the person still works at the company, and also if the decision makers for however it was handled, and presumably people are calling you because they thought it was handled inappropriately, if the decision makers about that are still at the company.
The decision makers usually are, and the employee usually isn't.
Yeah, I mean, so I don't know where this is going to go, but that's, I think if it were my agency or my company, that'd be information that I'd want to know, just to the point of, this is not about like what happens in litigation, it's just about like, okay, how can we make sure we're in the right place? So those are data points that, would be useful information, I think, from the employer side.
So unfortunately, we've run out of time, and I want to thank the panelists and Professor Estreicher.
I have nothing in the way of opening remarks except, closing remarks, except a note of gratitude for this wonderful panel and for the audience and for the folks that put it together.